Dick, please unmute, please.
Oh, sorry. I should. Is that better?
Much
No,
better.
I can still hear you.
That's the penalty you pay.
Okay, we can start. Dear ladies and gentlemen, we are starting our webinar dedicated to Lien on cargo and security for payment. This is an eternal topic for all times. From time to time, we need to go to some basics to review the practicalities and peculiarities. Black Sea and Mediterranean region is a short leg of transportation. Everything goes here very quickly, which adds urgency and gives no time to uncertainties during the voyage. It appears that Lien on cargo issues receive, let's say, new hybrid formats, and we are going to stop on this also during our webinar. We do not go into basics, into details much today. Our focus is rather to focus on the live discussion and to see the Lien on cargo from different angles. We have invited different professionals today for this live discussion, and I think that it will take about 2 hours for our webinar today. So we are going to today we are going to, these are our speakers. We are introducing this webinar together with the Black Sea Institute of Shipping and Trade Law. This is a public organization which is run by Interlegal and Richard Faint. This is initiative of Richard Faint. We launched it 1 year ago, and the main idea is to give an educational platform for keeping professional development on different issues of shipping and trade in the Black Sea. These are our speakers. The first speakers will be Mykola Kozachenko, it's a shipping lawyer from Interlegal, and then Igor Kostov, it's his cargo side lawyer. They will arrange a short case study. They will show some slides from our practice with what questions clients come to us. And then the next speaker will be Richard Faint. He's going to dive into some basics, how the Lien on cargo is regulated by English law. Then we have 3 professionals from shipping business. They are going to comment on what they face in their day-to-day business. These people are Armando Veras Sepulveda from Alpha Victor Sierra Limited. He's a chartering broker. Then Maxim Haulin, Intresco Ship Manager. Management. Maxim is going to share his experience from ship owners, ship management side. And Gennady Ivanov, BPG Shipping. His business is time charter operations. He is going to share his experience. And at the end of the story, we have two local lawyers. This is Lien from Dogu Interlegal, Turkey. She's going to speak on some issues from the Turkish perspective. And Karina Gorovaya is a partner of Interlegal. She's going to speak on the Ukrainian perspective. Not all pictures are on the slide because we have many speakers today and you cannot see Karina, me and Alexey Remeslo. My name is Artur Nitsevich. I'm a partner of Interlegal. I will be helping today our speakers, and my partner Alexey Remeslo, he's going to help today with the questions and answers. Please put questions into the chat. We will be monitoring the chats and we will try to cover all questions that come out from the audience. We have 90 delegates registered, which is quite good. No, of course, not everyone is online today, but we will circulate the records to all delegates and they will see the records when more convenient. Also, I would like to thank today our partners, media partners. This is European Business Association, APK Inform, Ukrainian Grain Association, Miller Magazine, Turkey, RDL Group, this is an event agency, latifundist.com and maritime.bg. We thank these partners that they share information about our activities and allow more people to join our event. Among the delegates, I saw by geography very wide geography, many countries, not only Black Sea. We have Bulgaria, Romania, Turkey, Georgia people, but also we have people from Greece, from Albania, from other Mediterranean countries, from Switzerland, and even from Malaysia and Korea. So it's a very wide geography. So just a few words about Interlegal. It's a law firm with a big focus on shipping and international trade. We do a lot of different legal work for people from the industry. We have a wide network of our partners all over the world map, especially in the countries that move cargoes from and to the Black Sea. And also we operate our business from the headquarters in Odessa, Ukraine, but we also run our offices in other countries of the Black Sea, which are Georgia, Turkey, Romania, Bulgaria, and Moldova. We used to have business much with Russia, but since the February 22, we stopped any business with Russian clients unless they show that they are against the aggression in public. This is our practice. We have 25 plus years of experience, and we process about 1,000 client cases per year. This allows us to to see hot topics in the industry from different angles. So we can start with the presentation, and I am giving a word to our studio where our guys, our shipping lawyer, Mykola Kazachenko, and our cargo side lawyer, Igor Kostov, will start from the short case study. The floor is yours, guys.
Yeah. Thank you, Arthur. Can you hear us? And do you see the slides?
Yes, we see the slides and we can hear you.
Great.
Come on.
Indeed, we are not going to dive deep inside the theory of Lien today, but we will rather focus on the real cases which we had and the way we proceeded with them, and how such matters can be resolved. And I will start with the case, one of the most recent ones, where we acted on behalf of the charterers under the voyage charter party. So we had a voyage charter party for carriage of about 40,000 tons of cargo from Ukraine to Turkey. It seemed quite straightforward deal, but it couldn't. Oh, sorry, slides don't work properly. Thank you. Yeah. Of course, the case where the Lien happened couldn't be a perfect one. So where the problem started? It was the matter of fact that the charterer indeed violated some payment terms, and they exercised late payment of freight and demurrage accrued in the loading port. So as per the charter parties, freight and demurrage had to be paid within some short period of time after the loading, but it happened that the charterer and its banks were not able to complete transfer within that time. That resulted in the owner's decision to stop the vessel on the way. It happened off Rhodes Island, and it happened just before the weekend. So the vessel was stopped, and the owners refused to proceed further unless they receive full freight and full demurrage. Moreover, they requested some additional payments, which they thought they were entitled to, but such payments were not accepted by the charterers because they were not clearly prescribed by the charter party. So it was a kind of dispute at the time as well. But anyway, the vessel stayed off Rhodes Island for 5 days, expecting the payments. After that, the charterer really wishing to proceed to the discharge because their buyers were pursuing them, and it was more important for them to deliver cargo as soon as possible. That made them to pay the demanded extra payments, and of course they affected freight and demurrage payments, which were not disputable. But for this 5 days off Rhodes Island, the owners calculated so-called demurrage. So they stated the stay was due to the charterer's fault, and as it was like charterer's fault, the charterers would have been liable for damages of demurrage. So when the first payment issue was resolved at Rhodes Island, another one occurred, and while the vessel was proceeding from Rhodes Island to Turkey, it was another stage of negotiations in respect of this new demurrage. Due to that, the vessel was stopped again, this time off Mersin, which was the discharge port, and the owners were more close to Iskenderun rather than to Mersin, exercising their lien on cargo for such unpaid demurrage. What was the charterer's position, which we tried to deliver to the owners, and which was the basis for our negotiations? So first of all, there was no right to stop the vessel and declare a lien until the vessel arrives to the discharge port. It was really the first point, which was quite crucial, because we understood that provided the vessel proceeded directly to Mersin, and even if payment has not been received by that time, and the owners would declare a lien there, which they would be entitled to, that would cause less damages than the ones accrued off Rhodes Island. Just because time of delay of payment would be shorter and time spent idle would be shorter, which is quite logically clear. So it was the first point, and we tried to argue this position based on the English law authorities and shipping practice, which quite supporting this position. The next item was that stoppage at the Rhodes Island, even if it was legitimate, would be rather detention, but not demurrage, even if detention, because demurrage is totally something within the loading and discharging operations, and there cannot be demurrage accrued somewhere in the middle of the sea. So even if it was legitimate, we would perhaps call it detention. And the next following point is that there is no right to lien for unpaid detention, unlike demurrage. This comes both from the English law, which outlines quite short list of reasons to lien the cargo. And English law also allows to agree on additional reasons for lien in the contract. But in the subject contract, as well as in the English law, there was no stipulation that lien may be declared against unpaid detention. That is why any stoppage of the vessel off the discharge port was again illegitimate, and the owners were not entitled to do so. These three items were the basis on which we claimed the owners to proceed to the discharge port immediately, start discharge, and that would give us the possibility to negotiate any disputes thereafter. So actually, there were quite many tiers of exchanges between the charterers and the owners, between us as the charterers' lawyers and the owners' lawyers, which ended up in some mutually acceptable solution at that time. So we agreed that the charterer paid 20% of the claim, but without admission of liability. So this payment was rather like a kind of partial security of the owner's claim, which would allow to discharge cargo and resolve the issue later. Owners proceeded to discharge against such payment, and now we are in active process of dispute resolution on the matter. But the main point was that the client's interest, which was first of all to deliver the cargo, to get paid for the cargo from the buyers, and to avoid any further demurrage, detention costs, and so on. This demand was satisfied, and now in calm conditions, quite clearly, we can negotiate the situation. And even if we don't come to an amicable solution, we can proceed with arbitration and handle it how much it takes, whatever, but we will come to some result later without accruing additional damages for the idle time of the vessel. That was one case, and the other one, which actually happened the same week as the first one. So we handled two almost similar cases together. It was carriage again from Ukraine, but this time to Georgia, and the ship owner alleged that the contractual terms in the recap were not the ones which he wanted to agree on, that there was some trick or something else. So in the end of the day, he demanded some additional detention or demurrage costs of about $100,000. So this resulted in the owner's decision just to deviate to Trabzon, stop there, and wait for the payment of his demand. Again, we used almost the same arguments, of course, subject to other terms of the charter party. And luckily, that deviation didn't last too long, so we persuaded the owner to proceed to the discharge port much faster than in the first case, which resulted in quite minor losses of the owner. And we successfully discharged the cargo, paid what the charter had to pay, undisputed demurrage, freight, and so on. And again, now there is a dispute regarding the substance of the claim, whether the ship owner is entitled to claim anything in addition to what have been paid. These two cases are representing our most recent practice acting on behalf of the charterers. And of course, we also had cases where we acted on behalf of the owners, and that is a totally different story. We understood that the ship owner was really entitled to demurrage payments in accordance with all the terms of the charter party, and actually the charterers even admitted that, but the charterers didn't pay that. And we realized that the only way to protect the owner's interest would be to declare lien on cargo, because the vessel stayed idle for about 2 months, and the demurrage costs were just incredible. But even though it was the only way to safeguard the owner's interests, the owners, acting commercially, decided that they could not stay anymore because they had to proceed on the next voyage in order not to lose it, in order to earn money, and to have dispute later. Actually, that resulted in the situation where the cargo has been discharged, and exactly after that, the charterers just stopped replying any messages. quite logically. So now we have dispute on the marriage, but without active position of the charter. So that is another story when lien on cargo is not exercised, and that is the risk for the owner that he might face some further long-term issues with collecting that the marriage. At this point, I guess I am done with presentation of our recent practice in lien on cargo issues, and perhaps my colleague Igor would tell something on a different side, what sellers and buyers do in the same situations.
Thank you, Nikolai.
Yes, Igor, please. Yes. Go from a different angle. Let's see.
Okay. Thank you, Nikolai. Thank you, Arthur. I'm a trade lawyer, and I deal with international trade, with dispute resolution and arbitration arising from the trade contracts. And when I say about trade contracts, I mean the contracts of sale of commodities, and such contracts are governed by English law. So Nikolai already explained how the lien works in shipping, and I will try to briefly explain how the lien and security for payment work in trade contracts. Lien on cargo and security for payment may be implied by law and also may be provided for in the contract. When we say about the law, first of all, it's a Sale of Goods Act of 1979. This is the English act which governs the international sales. And the section 39 of the Sale of Goods Act provides that if the seller didn't receive payment for the goods, and even if the property in the goods passed to the buyer, the unpaid seller may exercise lien on the goods or have the right to retain the goods until the payment of the price of the goods. But the unpaid seller has the right of lien on the goods only while he is in possession of the goods. So in other words, the unpaid seller may exercise lien only when such seller controls the goods, when he have control over the goods. Next, the section 42 of the Sale of Goods Act deals with partial deliveries of the goods. And this section provides that if the seller supplies the goods by parts, if one or a few parts are not paid, then the unpaid seller have a right to exercise lien or the right to retain the remainder of the goods until the payment of the unpaid parts is done. And also the Sale of Goods Act set out circumstances when the lien on cargo shall be terminated. So first of all, the unpaid seller loses the right of lien on cargo when he delivers the goods to carrier or bailee. For example, if the seller sold the goods and load ships them on board a vessel, even if the seller did not receive a payment for the goods, he loses the right to lien on cargo because the goods were already passed to the carrier with the purpose of transmission to the buyer. And also there is another cause when the unpaid seller may lose the right to lien on the cargo. It's sorry, the screen didn't show the full slide. Also, one moment, please. Also, the seller may lose the right of lien on the cargo when the goods are passed to the buyer and when the buyer obtains legal possession of the goods. So once the goods are passed to the buyer, even if the seller was not paid, he loses the right of lien according to the Sale of Goods Act. Of course, lien on cargo or some ways of security for payments may be provided by contracts. On the screen, you can see the typical payment clause, which is used by majority of the contracts for sale of commodities. And this payment clause provides that the full price of the goods to be done in any event before breaking bulk. In other words, that means that the seller has a right not to allow discharging of the goods before receipt of 100% of value of the goods. However, this clause may be interpreted too wide, and this clause may be too ambiguous. So it's better to use this clause in with some additional wording, providing that any delays at discharge port due to late payment shall be at buyer's risk and for buyer's account. This is also a typical wording of the payment clause, which is used in the trade contracts. And in such a case, if a seller delivers the goods to the buyer to discharge port, and if the buyer doesn't pay for the goods, the seller has a right to retain the goods until payment, and all delays at discharge port while waiting for the payment shall be for the account of the buyer at risk of the buyer. However, not only liens can be used to secure the payment in commodity trade contracts. Recently, we had a very interesting case where our client was a seller under a CIF contract, and the buyer arrested a vessel at discharge port to secure the payment for allegedly short delivered cargo. So our client approached us requesting assistance to resolve the situation. In fact, the seller, CIF seller, loaded the goods on board of a vessel. The vessel arrived to Turkey, to discharge port. The Turkish buyer paid 100% of value of the goods, and the discharging commenced. Where the discharging was almost over, and only 5 metric tons remained on board the vessel, the buyer stopped discharging and said that there is a huge shortage, and requested the seller to pay a price of short delivered goods. Of course, the seller refused, and the buyer arrested the vessel. the buyer arrested the vessel according to Turkish law, and Turkish law allowed the buyer to arrange such arrest. So the buyer continued to claim payment of short delivered cargo, pushing the seller. In such a case, the seller was in a difficult position because the discharging was not completed. The vessel was already on demurrage, and according to the rule, once on demurrage, always on demurrage, the owner counted demurrage every day, and the owner pushed the seller to resolve the issue because he reserves the right to claim demurrage from the seller. Here is the contract clause. Apologize, but it seems on the screen you can see some words are confused. Anyway, I will explain. In the contract between seller and the buyer, there is a clause providing that if the shortage at port of discharge exceeds 0.5% of the weight indicated in the bill of lading, the seller have to pay the difference within 20 days from the date of provision of the documents proving the shortage. And such documents need to contain report of the GAFTA first-class surveyor. When the buyer started to claim shortage, he did not provide any weight report of the surveyor. So, in fact, the request of the buyer was unlawful and contradicted to the contract. And of course, the seller was not obliged to pay the shortage without presentation of the evidence of the shortage. And in any event, the seller had a right to pay within 20 days after presentation of the weight report. So of course, we advise the seller that his position is secured and his position is right, and that the buyer's request is unlawful. At the same time, the charter party between the CIF seller and the owner, ship owner, contains the sealing clause, according to which the vessel hulls should be sealed after the loading completion. And if at the discharge port the seals are intact, the owners should be not responsible for any shortage, and the charterer, being the seller under the sale contract, is obliged to resolve any shortage issues with the buyer directly. So, according to the charter party, the seller could not claim any shortage from the owners and was obliged to pay shortage to the buyer in case the buyer can prove the shortage. Thereafter, after the arrest of the vessel, the buyer finally provided the surveyor weight report showing the shortage. We managed to persuade the buyer that his position is wrong. He is obliged to cover unlawful delays. The buyer agreed, and we managed to settle the case. The seller paid shortage to the buyer paid covered the demurrage, which should be paid by the seller to the owner, and the issue was finally solved. Anyway, this case shows that there may be a lot of different situations and a lot of different methods to secure the payments under the sale contracts. Anyway, such methods and the outcome of such securities will highly depend on the terms of the contracts and the factual circumstances of each case. At this stage, my presentation is over. I believe my colleagues have a lot to add and to develop the Lien and security for payment topic. And I'm happy to pass the words to further speakers.
Okay, Igor, thanks. We have a few questions in the chat, but also we have a few questions which were forwarded to us during the registration.
Artur, can I try
Yeah,
to
sure.
collect them in some one question? Of course, I want to summarize it and ask this, how to say, big question to Mr. Richard.
Oh dear.
It will also summarize the case study just presented by our speakers. So a lot of questions which we received were about this long chain of negotiations, the time charter, the voyage charter, the receivers, etc., etc. And this is the huge problem for the party being on one side or another to find out how to manage with this. So we received the questions from the charterers, the voyage charterers, from the receivers, asking a lot of questions about where to see our right on the lien in the bill of lading or in the charter or where. So can you follow this chain, a very brief, of course, and just some practical advice for the parties where to start. Of course, they need to call their lawyers at first, and they will manage with this. But in general, this chain, how to manage with it?
Okay, Chief, if I can comment now.
Yeah.
The simple answer to that large question is possession. Who has possession of the goods? And invariably, it comes down to the dockside. If the receiver wants the goods, the ship owner or whoever's raising the claim wants money for services rendered, carriage of goods, whatever. Yes, there are a huge number of people involved in international trade sales. Cargo gets sold from A to B to B to C. It could go on forever. But when you are, international trade is the sale of documents rather than physical goods. The question here is the security comes from physical possession of the cargo or the ship. So although there are any number of people involved, it usually comes down to an argument between one or two people. If I could just use that question to go back over the case studies. The first one raises an interesting point. 5 days delay off the island of Rhodes. Okay. This sounds reasonable from the owner's point of view. He's looking for his money. I have the cargo. I'll just wait here until the money arrives. No, that's not a good idea, either from the owner's point of view or from cargo's point of view. There is SIF sales give no guarantee of arrival. There's a risk. There's always a maritime risk. The ship may sail, may sink in a collision, whatever. Let's call that a trade risk. But there's no guarantee unless you put in the sale contract to suit arrival by a certain date. There's no guarantee of how long that voyage will take. So it sounds reasonable for an owner to say, I'm going to wait here until the money arrives. This is covered by something in English law using a Latin expression, stoppage in transitu, right? Generally, let's see, this generally comes up if you find out that the buyer has gone insolvent, it's in bankrupt, or simply doesn't have the money to pay. Yes, you may have a right of stoppage in transitu, but that's the right of the owner of the goods, not the ship owner. Are we clear on that? Right? The ship owner's duty is to proceed with all due dispatch, having due regard to the weather, whatever. Take the example of the Russian invasion of Crimea. A war may break out, which prevents completion of the voyage. There may be reasonable answers as to why the voyage is not being proceeded with all due dispatch. That doesn't mean that you can hide off roads waiting for payment. That's not stoppage in transitu. You know, that's the owner deciding to take some action against the duty to proceed with all due dispatch. That first case, okay, the solution worked out by Interlegal seemed very reasonable to me. If it's going to arbitration, I will not be the arbitrator, but I would say that cargo are in a very good position there. The second case, the cargo to Georgia, dispute over the recap terms, is an argument to say, well, there was never any contract in the first place. There was no agreement, no complete agreement on the terms of the charter party. That raises a very interesting point. The owner deviated. He went somewhere else. He tried to hide again, waiting for payment. There's another simple answer in that second case. All right. Again, if the basis of this sale contract is English law, which I imagine it was, usually the bill of lading will follow that it's to be governed by English law. If there is an argument over the terms of the carriage, then what is the contract of carriage in that question? If the parties can't agree the terms of the contract of carriage, English law would call that carrier a common carrier. Yeah. That's very interesting from lawyers' point of view, mostly unrecognized by ship owners and probably traders. Under the common law system, the carrier would agree to take the cargo from A to B and can only expect payment when he gets to B. You know, the definition of freight, carriage of goods for a fee payable on right and true delivery at the port of destination. Okay, right. Now we go fast forward a few years. We have the Harter Act, the Hague Rules, the Hague-Visby Rules, and the Hamburg Rules. These are all conventions, terms for the carriage of goods by sea. In the second case, if the owners and the charterers cannot agree, have not agreed, there's a dispute over the recap, the ship is at sea, so the owners have possession of the goods. They have to agree that the basis of the agreement was to carry the cargo from Ukraine to Georgia. If they cannot agree to terms, then that cargo is being carried as a common carrier, and that owner does not have any right to demand freight until he gets to destination. Any attempt to demand freight without an agreed contract is an attempt at extortion, demanding money without providing the service which the common carrier has to give. The common carrier has to carry from A to B, Ukraine to Georgia, and deliver the cargo. Once he's delivered the cargo, he has that right to demand the freight for carrying. If you can't agree to terms and conditions of the charter party, the contract of carriage, contract of affreightment, that owner is a common carrier. So I offer that as a solution for the second case. The interesting point, of course, with a common carrier is that he has to deliver the cargo in the same good order and condition that it was loaded. If it's 1,000 tons, he has to deliver 1,000 tons. If he is 1 kilo short, he's in breach of his common carriage agreement. So I leave that with you. Under the trade contracts, yes, references to section 39, 42, 43, very interesting. Query practice of the trade at the moment, and this I think goes back, excuse me, excuse me. Excuse me. Yes, section 43, delivery to the carrier is somewhere where the right of the lien is passed over. I would argue against that because most sale contracts these days are sold free in and out, stowed and trimmed. So simple delivery to the carrier isn't a handing over the cargo until the loading operation is completed. So if there's any hazard problem at the load port, which an argument over the weight loaded, for example, loading is not said to be completed. The ship owner is only required to issue a bill of lading on demand of the shipper. If the shipper has a, makes a written demand, a bill of lading has to be issued. Okay, so there's a query there of, does that lien apply under section 43A? If the parties have otherwise agreed that property and title will not pass until the whole loading operation is over, completed, then you come back again into the Sale of Goods Act, and I would say have a look at section 19A. 19A is quite interesting because most bills of lading are issued to order these days, to order the ship or whatever. The shipping documents are then presented for payment. Section 19A is understood in English law as the seller retaining the property in the goods until he gets paid. This can lead to some strange problems. I had one recently. If the seller is selling on credit terms, payment within 120, 180 days, he presents the shipping documents, valid shipping documents to the bank or to his buyer, knowing full well that he's giving up possession of the documents because his buyer may well sell on the goods within that 180-day period. So there you have another problem. Section 19A of the Sale of Goods Act says the seller has the right to retain or keeps title to the goods, even though he's given over shipping documents to a buyer who can trade them on within a 180-day period. So something difficult doesn't come up very often. When it does, it creates all kinds of problems. I mentioned to Arthur this particular case in Singapore where the underwriters and the banking lawyers were arguing that the defense of the claim was a change in the cargo manifest. Absolutely crazy, but that's another story. Okay, those are my comments on the cases so far. Stoppage in transitu, a very strange peculiarity in English law, perhaps. Doesn't come up that often, but it is something to keep in mind. The basic proposition is that the ship owner must proceed on his voyage with all due dispatch. He can't hide or claim that he's waiting for payment, that he doesn't have that right. He has a right to lien at the port of destination, not before. To claim detention by hiding off roads, I don't think that would work. That owner would lose that argument. A sideline is when you have arguments over a vessel being detained because the lake hand has expired a long time ago, damages usually are granted on the same basis as demurrage. So although you might be claiming detention, you will probably end up with a demurrage rate anyway. Those are the way the case is going. Okay, I'll get off my high horse now and maybe go back to what I was going to start with. A resume on liens. What has been pointed out so far is that a lien requires possession. In general law, a lien is a limited right over property. So it's a remedy, it is available under certain circumstances. So you can divide it into particular liens and general liens. Particular lien, the right to possession of the goods. The easiest example, which I think I've probably mentioned before or in other lectures, consider what happens when you put your car into a garage, all right, for repair, whatever. The garage has a lien on that car. They will not give back possession of your car until they get paid. Usually described as a garage mechanic's lien. Very simple. Hotel operator would have the same kind of lien. If you've left your luggage in the hotel, he can hold on to your luggage until you pay your bill. Same principle, a garage mechanic's lien. Maritime lien, right, here we have some difficulty. It's said, okay, in certain academic circles, that you've got to understand the history of maritime law before you understand maritime lien. Okay, that's probably correct. This is not a history of law section, so we'll move on. Maritime laws do differ from country to country. I can only speak on really on maritime law in the UK. I've also already mentioned common law. The common carrier the common law would deal with the ship in the second case. An owner who's loaded the cargo, sailed away, and then is arguing over the terms of the contract, he would be treated as a common carrier. Common law would treat him as a common carrier. Okay. If you give up possession, you generally lose the right to lien. English statute law, the closest we get to having the civil codes, gives the Merchant Shipping Act, for example, gives protection to seamen, protection of certain rights and remedies. He has a right to lien for his wages. Okay. Problems associated with maritime liens in rem actions. Okay, here we come to the description in rem. In rem, a Latin term, just means a thing, an object, property. All right. You have an action against a property. Your problem is with a maritime lien is you don't have possession of that property. So how to get around that? Believe it or not, although this case refers to something in 1852, it was only in 1852 that the courts first looked at this question in rem, where you don't have the property and that right of an action against that property. The case is called the Bold Buccleuch. It was a Scottish ship. Peculiarity of the British legal system is it's not one system. You have England and Wales, and in some cases Northern Ireland. Scottish law is different. It's closer in some ways to civil law. So a Scottish ship ran down. This is a sailing ship, ran into another ship in the River Humber. Proceedings were commenced in the area of the River Humber, but the Scottish ship sailed away before she could be arrested. So, as I say, despite being part of the UK, Scotland has a different legal system. The ship was later sold in Scotland by the Scottish owners, and the new owners did not know of the arrest that had been placed on that ship by the English courts. So the English warrant of arrest was executed. Proceedings under that warrant were allowed to continue. The current owner, the new owner of the ship, knew nothing about this. the English court says the injured party had a right in the ship to go against the ship before the ship was sold to the new owner. That right was created by the collision, and it stays with the ship, it stays with the property, even after the sale of that ship. So it stays with that ship, never mind into whose hands that ship goes. Technically, this is for the lawyers who are listening, the right of arrest was said to be incomplete. You use the English word inchoate, which is something that needs to be perfected, and you perfect the arrest against the property by that action. You can lose that right to arrest by delay, sure. But it's got to be something of an unusual delay. The courts can extend it. Okay, just let me collect my thoughts here. So this right of arrest against the ship arises from a cause, a collision in this case, and travels with the ship. Even if the new owner doesn't know anything about it, that right to arrest is still there. So a maritime lien does not require possession of the property for its creation. I hope I make that clear. You do not need possession of the property to have a maritime lien. But a maritime lien is also different in that it gives the right of whoever has that lien for the sale of that property if there's no settlement. So I think probably correct to say a maritime lien in general requires proceedings to be commenced in the jurisdiction where the property is or was. Yeah, the Humber collision gave a right for arrest in that jurisdiction. It's important because the presence of the property in your own jurisdiction would usually satisfy process concerns binding out of court, out of state claimants to that judgment. So the judgment in the Humber bound the Scottish participants. I've made a note here. This is a strange area. Be careful. Ask Arthur and his team. If you are in this situation, you will need legal advice. Okay. I could go on forever on this. I think probably I will stand down now. I've probably exceeded my 15 minutes and wait questions. If anybody needs clarification, please ask. Arthur, over to you. Or Alex, sorry.
Yeah.
No problem. Richard, I have one more question, which is more or less general. What would be, I will quote, what will be a governing law of the cargo lien? There may be two aspects. Substantive aspect, whether the ship owner carrier is entitled to lien the cargo, and the second one, procedural aspects, how to exercise the lien. So in general, where is this, how to say, border between these two legal systems, the English law during the voyage and the practical stage in the port, which is, it seems, governed by the local law?
Yes, always.
How to manage with this?
Always it is governed by local law. It's difficult. It's not easy. In Ukraine, from my own practice, I think you can arrest, and the question of the jurisdiction of the contracts of carriage and sale are then something that the Ukrainian judge would have to decide on, whether to give preference to what the parties have agreed is something that would be decided locally. I can't really answer that because I've seen it go both ways. I've seen local, the jurisdiction of the state where the claim is being made. I've seen cases go both ways. Sometimes they will recognize the agreement of the parties in the contract of sale, the contract of the charter party, or the bill of lading. Sometimes no, they will go to the local jurisdiction. Made even more confusing, if you have a Hamburg state jurisdiction, then the argument is very definitely a local argument. You know, the receiver has the upper hand. So I cannot really give you a full answer on that. It really depends on how the judge is feeling on the day in the local court.
Thanks,
Thank you,
Dick. I think yes, this really differs from the country to country.
Yes, very much so.
Although there are many countries all over the Black Sea and Mediterranean, and mainly they're based on the continental system of law. But in each country, in each, let's say, province, in each city, each judge can decide on his own views, and this makes life of shipping people not easy in this respect.
It gets even more complicated than that. Interlegal is part of the ship arrested organization. In one of the conferences, there was a case presented. It was Russian. The judge found in favor of cargo, and the judge was then removed, and we were told that the judge's award was a mistake. So it's always down to local jurisdiction. It can go to very strange extremes.
Thank you. Richard, one more question.
Sure.
Let's try to make it simple. The question is about the lien against the receivers under the bill of lading, which are not the party which are not a part of the charter party, etc. What about this?
A claim by
the lien against the receivers, the final receivers in the port of discharging,
so
which are holding the bill of lading and not a party to the chart and not charterers.
So the receiver has the goods in his warehouse.
Receivers have a bill of lading and waiting for the cargo, and there are some problems with the freight between the charterers and the disponent owners or the head owners. And for example, the disponent owners try to exercise the lien, but they are claimed by the receivers in the port of discharging, which know nothing about the freight and other problems of the voyage.
Well, although the receiver may have the holder of the bill of lading may have a claim against the carrier under the bill of lading for non-delivery, I don't see how he could have a lien, because one, he's not a party, he's a sub-charterer, if you like. He doesn't have possession of the goods, and there's no cause of action which would give him a right of arrest against the property, because he has a right to demand delivery from the carrier under the bill of lading. So where would he be able to create a lien?
Richard, sorry, not create. In fact, you're right. The receivers are claiming the delivery of the cargo.
Yeah.
But in the same situation, the carrier has trying to use the right of the lien of the cargo against the freight from the charterers, but not the receivers.
Okay. So, well, the owner's right to a lien is clear. So the receiver goes backwards in that situation. He has a clear lien on the cargo for his unpaid freight. It gets a little more complicated if there's a charterer or sub-charterer, time charterer. It's more difficult further down the charter party chain, it's more difficult to make an arrest. A lien for hire is not, hire is not a property, it's something due. So there's no lien for hire in such a circumstance. You have a lien for freight because that's a traditional lien. But so the owner, yes, he has a clear lien for unpaid freight against whoever's due to pay him. Further down the chain, the receiver can waive his bill of lading for all he likes, but until the owner gets his freight, yes, he has a right of lien at the port of destination, or as close as he can get. I mean, he can anchor off the port. He can't wait 5 days off roads. There's the difference. Does that help?
Yeah, of course, it's clear now because this is a lot of questions in this respect. From the
sure.
receiver side, how to act in this situation. I'm a holder of bill of lading, and there is some lien in the email correspondence. I don't know what to do. So this is a common question.
Alexei, just a comment from my side. Perhaps in such a situation, the receiver, being a buyer under the sale contract, might have some action against the seller, who is a charter and who may breach the contract by not providing possession to the goods under the contract.
Well,
so it depends on the terms of the contract between the receiver and his seller.
Well, yes and no. Again, we come back to proceeding with the voyage with all due dispatch. Once the seller has presented documents, the risk of the voyage, it's not on the seller. The normal risk of the voyage is fire, hazards, whatever, it's on the buyer. There's no guarantee under a CIF contract that the cargo will ever arrive. If freight is to be paid, who is to pay that? If it's a CIF sale, generally the seller has guaranteed that freight will be as part of the contract. Carriage insurance, freight. But if the owner has not received the freight, his answer is the lien on the cargo. Doesn't help the receiver. The receiver may have the buyer may have a claim against the seller for an unreasonable contract of carriage. Is this owner playing games? We don't know. But that kind of risk usually goes from the seller to the buyer once shipping documents are presented. If the shipping documents are in order, you have a valid bill of lading, the contract of carriage. Right? There's been an agreement between the carrier and the shipper to load the goods and to issue that bill of lading. The charter party always comes first. Between buyer and seller. I'm going to sell you 10,000 tons CIF. Okay, shipment 1st of November. I then have to find a ship to load the cargo. The bill of lading comes later, but becomes the most important document, because with the bill of lading, you can transfer property and title, provided you get paid. Right? The owner sitting in the middle here, he's going to provide a service carrying the goods for which he is entitled to his freight. If that freight doesn't hit his bank account, he has that lien. So it's difficult to see how you can go back into the sale contract for unpaid freight.
Yes, and Richard, in modern practice, I saw a few contracts which clearly states and oblige the CIF seller to ensure that the freight is paid. Otherwise, any delays at discharge port and any damages of the buyer should be covered by seller.
Totally agree. If that's in the contract, fine. But how often these days do you see bills of lading which are not freight paid? Or the arguments usually come when you have a bill of lading freight payable as per charter party, then you open the door to a nightmare. It could be a time charter. The goods carried under a time charter, hire is not freight. So most sale contracts, freight paid bills of lading or freight prepaid. So, okay, there may be reasons why the owner hasn't got his freight, but that generally should not concern the seller. If he has presented freight paid or freight prepaid bills of lading, he's completed his side of the bargain towards his buyer. Yeah, do you agree with that?
Yeah.
So again, that doesn't remove the owner's right. If the freight is not in his bank account, he has that lien.
Yeah.
Okay, gents.
Arthur, sorry,
Yes.
I think this is the best time to listen the people from the shipping side, because we are at the point of the discussion where it is very important for them, and
Agreed.
it is interesting to hear from their side their practice or questions maybe to our speakers.
Yes, I think best time. Yes, best time to ask people from shipping what they face in their business and what general recommendations they can give to the market. First, let's start from Armando. Armando, please tell us what business you do, and then you can go to your ideas, let's say. Please.
Yes, well, I'm a chartered ship broker. I focus mostly on sell and purchase. I do more sell and purchase than chartering. Nevertheless, I do engage in chartering broking at the same time. From a ship broker's vantage point, I can say that when it comes to negotiations, the lien clause should not be a sticking point, should not be an issue when negotiating. It's pretty much standard, because otherwise, if a charter or a prospective charter in the middle of negotiation starts raising grievances, or is difficult at the when it comes to negotiating a lien clause, or is trying to include a more loose, more fuzzy wording, then that's a big red flag for any prospective owner that is considering to fix a voyage charter or even a time charter. So it's a big red flag for any ship owner who encounters a prospective charter in the middle of a negotiation who wants to impose a very strange non-standard lien clause. So I do see that in the chat there's still an open and unanswered question regarding whether a disponent owner is entitled or not to exercise a lien under a GenCon voyage charter. And because one of the lawyers in the chain apparently said that only head owners and not disponent owners can exercise such a lien. I'm not giving advice under any jurisdiction at all, so this does not constitute legal advice. Nevertheless, the incorporation of the relevant charter party, whether is the voyage charter, the head time charter, or both, it needs to be clear cut in the bill of lading which charter parties are incorporated into the bill of lading, so that the holder of the bill of lading can be better aware of who may have rights to exercise a lien. So answering this question, that it remains open. Now, unfortunately, the answer I would say is depends on the actual wording of the bill of lading itself as to which charter parties are incorporated into that bill of lading. and then it will depend on what the charter party says. If it's a GenCon, let's say the GenCon clear cut and clause 8 says that the owners do have a right to lien on the cargo, and if on that GenCon, on the relevant box in the box number 3, owner's place of business, if whoever is stated in that box is pretty much the owner, therefore is the party that would have the right to exercise a lien. And if that party is the disponent owner, then I would say that in such a hypothesis, that disponent owner should have a right to exercise a lien in that case. I'm not sure if Gennady would have a different answer or different approach to this question, and with his vast experience as a operator and as the time charter and voyage charter carrier, yeah, he can provide far more insight. I hope I was clear.
Yep. Yeah. Thank you, Armando. Thank you, Maxim. Your side, please tell what Centresco is doing and what usually you do in such situations, in such cases when lien on cargo comes out.
Yeah, I represent shipowning and ship management company, and I will just give a few cases which we have and how we fix the vessel on the voyage basis. So I will not touch any time charter issues. I leave it to Gennady because he's more experienced with this. And I would like to tell you that in my experience, which is today a little bit more than 20 years old, we have never exercised any lien of the cargo. We have some maybe attempts, maybe some threats to the charters for the in our history, but I can tell honestly that at my own point of view, this is practically impossible for the owner to lien the cargo. It's very, very dangerous, and I strictly recommend to all managers and ship owners always to avoid this scenario. In order to avoid this scenario, we have very few and simple pre-actions which we have to do during the fixture, during the making the fixture of the cargo. Okay, today we are calling this risk management, but anyway, this is just number of few steps which you have to take into account. Firstly, you have to understand with whom you are fixing. You have to know the charters. You have to know the charters, you have to know their background, how reliable they are. And I think this is 99% that the freight will be paid. And you don't need to think how I can lien the cargo and which steps I have to undertake. Secondly, of course, the best the best scenario is when you fix with the charters the same charters as the receiver. This is, you know, the perfect opportunity that you will be able to do something. Because as we discussed previously, the ship owner can exercise a lien over the freight, on the cargo over the freight, only if the cargo is owned by the charter. Because once the bill of lading is signed, you have a contractual relationship with the receiver. You have to be very, very careful, because this is like Richard explained, two different things. Charters and receiver, they're different. And once you have these bills of lading, you have to be very careful, because there is nothing to do with the charters anymore. That's why the second agenda of this risk management is how we mark the bill of lading. I mean, if the bill of lading is marked freight prepared, there is no any chance, at my point of view, to proceed with the lien of the cargo. And the last thing which we do also is when we fix the vessel. So we have the charter's name, we have how the bill of lading is marked, and now we have to check what will be the country of destination. We discussed already here that in case of the lien of the cargo, we will apply for the jurisdiction, for the law of jurisdiction of the country of destination. And to be honest, there are only maybe few countries in the world which are really practical for the lien of the cargo. Most of the countries they protect the receiver. In most cases, the receiver is already the owner of the cargo. As Richard already told, the seller guarantee, normally the seller and charter, they guarantee the payment of the freight. So when the cargo, you can lien the cargo only at the port of destination. And that's why you have to be sure that you cannot go against the receiver in no cases. So what we do normally in case we face with non-payment of freight, we normally use only the psychological not attitude, the
Pressure.
way actions.
Pressure.
Yes, pressure. Yes, this is at my own of view the only way how you can convince the charterers to pay the freight in case they are trying to delay, in case they are trying to escape or whatever. Why? Because most of the charters, they have a contractual relationship with the receiver. In many cases, they have long-lasting relations. So what we're trying to do, in case we feel that it will be, not feel, we see that the freight is delaying, the payment of the freight is delaying, we send the notices to the agents at discharging port that usually was the master to do it, that vessel is arriving, there is no freight, we will not enter the port. Also, again, we're checking the country of destination, the law, we're checking by ourselves. At this point, at this stage, we do not approach the lawyers, and in most cases, we will not enter the economical, let's say, natural waters of the country. So we are saying this also to the discharging port agent, apart from the charterers, because the discharging port agents, normally they will very quickly bring this information to the receivers. And the receivers in turn will contact the charterers and they will ask the charterers, what's going on? I mean, we paid for the freight, we paid for the cargo. The cargo should be delivered on the CIF basis. Freight should be paid by you. Why you don't pay the freight? I mean, when you come to this point, in most cases, the freight will be paid by the charters. But again, we're doing this on the basis of their negotiations. It's not something, we don't undertake any legal steps. And also, when we come to this point, we have to be very careful with keeping our relation with the charters. This is a very unique moment, like a balance, because from one point of view, you as the owner, you have to receive the freight, of course, and you know that your legal position is very weak in order to exercise the lien of the cargo. From the other side, if you approach the receivers or discharging port agents and you will tell them that your charter didn't pay the freight, don't pay the freight, then the charters maybe don't like you. And in the future, you will have some issues to work with them again. So this is some kind of balance. I think Armando understands what I mean, because he is acting as a broker. And normally, this will be the broker, the broker headache. Because charters will say to the broker, where did you find such kind of owner? There is only a few days of the freight delay. it's only the first time we had this opportunity. So this is the balance which the owner has to keep in mind when he is claiming the payment on the freight, when he is saying, I will exercise a lien on the cargo, but of course, he knows that it will not work, or it will be not really practical. And again, Armando has already told, in order to exercise a lien on the cargo, a relevant clause has to be incorporated. But again, in most cases, in most cases, we have to deal with the law of jurisdiction of the destination country. Not the English law, not Ukrainian law. It can be Algeria, it can be Morocco, you know, if we're trading here. Thanks to God, for example, if we go to Italy or Spain, then of course we are protected, because these kind of countries, they have a quite good law which is connected with a custom. So in most cases it is possible to discharge the cargo without original bill of lading. The cargo will be released only against original bill of lading when the receiver will pay the freight. The receiver will pay the value of the cargo. Why? In some cases, everybody knows here that sometimes payment of the freight is connected with the payment of the cargo by the receiver. In many cases, the charters, being the seller of the cargo, they are collecting the value of the cargo they are selling from the receiver, and then they are paying the freight. Sometimes, I mean, this is possible, and that's why in some cases we had such cases when a delay of the cargo or of the freight was directly connected with the payment for the cargo. And the charterers approached us and they told, oh, sorry, our receiver is not paying the freight. Please wait. And we understand this because we're trying to work with the charterers with whom we have established relations. We're trying not to work with the new charterers. Only maybe, you know, recently when Ukraine faced problems with export, we have now many new charters from Ukraine. Then we're trying to make due diligence. We're trying to understand how financially they're based, and but again, this is some kind of risk which is compensated by the level of the freight. But again, I recommend to the owners, when they think about the lien on the cargo due to non-payment of the freight, to be very careful and balance between the charterers and the future trading of their vessels, because it can be a situation when they have to come back to these charterers again and fix with them. Again, I just would like to underline some basic point that ship owners can exercise a lien on the cargo or due to the freight is not paid only if the cargo is owned by the party charters, by the same party. And secondly, when the master, the owner, signed the bill of lading, he is stepping into contractual relationship with the receiver, not with the charters. And he has to be very careful, and he has to study bill of lading very carefully. A lien clause has to be incorporated in the bill of lading. He has to see who is the receiver. Sometimes it is to the order, sometimes this is the bank. And if there is a bank, he has to be also very careful. And the owner shall have a line on the cargo for freight incurred in the port of loading only to the extent of the amount which they due. We discussed about this. I mean, if there is any detention or there is any demurrage, in most cases, unless it is not agreed somewhere, the owners don't have any right for lien on the cargo. It can be only the freight. Basically, this is what I would like to say.
Maxim,
Yeah.
thank you very much. Very clear, very straight to the point. Thank you very much. Gennady, all colleagues were announcing that you are more experienced in time chartering business. Please tell from your side, please, what you think about it.
Yeah, thank you. Good day to everybody. Maxim, as owner, said that his position as owner is very weak. So what to say about time charter operator? I represent time charter operator, so our position is the weakest one. And after this seminar, I got I strengthened my opinion about this. So in general, for me, as a time charter operator, lien is a question, first of all, the proper risk risk management or counterparty risk management. And therefore, for last 3-4 years, fortunately, we didn't face this necessity to invoke this tool. However, in the past, when we had, maybe because we became more wise, I don't know, but in the past, when we had more than 100 vessels under TC at the same time, it was not easy to implement this counterparty risk management. And in some cases, we faced with non-payment of the freight. And our plan of actions was pretty much similar to Maxim said. So first of all, we are trying to create a pressure. Because usually the freight payment to be done after 3 days, in 3 days after BL is signed, vessels sail from usually the same time. It's coincided with that period when vessels sailed from the last discharge port. And we're trying to create a pressure. Okay, first of all, we're trying to find out what is the reason, because usually, in most cases, the delay with freight payment because of trading matters, there's somehow the link. So we are trying to understand what is the background of non-payment of the freight. Later on, we are trying to create some pressure by sending some official notice of intention to declare the lien. Usually, we send this to all parties involved: shippers, receivers, agents, stevedore terminals, everybody. So the reason of this is to create some noise, some pressure to the charterers, and let's say in most cases such tool is very efficient. Because of course we realize that declaring a lien, it's an extremely difficult thing, because time charter operator is not a carrier, and there are so many dangers, let's say, which by declaring the lien we can create so huge problems for all parties involved. So, but we had a case when we proceeded to declare the lien, and let's say, can say that was a mistake. We declared the lien in one of our vessels was loading in Europe, in Croatia, and the discharging port was in India, in Mumbai. So we arrived. By the time the voyage was very short, and of course we didn't receive the freight. We started to create the pressure and started to negotiate with charterers, etc. So by the time vessel arrived to India, we failed to receive the freight. So we stopped outside of territorial waters. It's very important. Remark: vessel was staying outside of territorial waters, and we declared the lien. But vessel was brought into the port by force with the involvement of warship and shot into the air. So you can imagine the Indian involved a warship started to shoot into the air. So ship was arrested. Ship was brought alongside. She was arrested, and at the end of the day, the losses were huge. And for us, it would be more easier just to discharge without the freight. So we compare our losses, and to release the vessel, it was a huge difficulty. also had it was conflict both with the charters because of non-payment of the freight, also with head owners, because head owners they warn us that please don't do it. Don't do it because we will be not in position to be on your side. So it was a mistake of ours, but it was let's say experience. It was a long time ago, but like 2000, I think it was 2012 or something. Even it was an article in TradeWinds about this. So for us, it's very simple. We are trying to implement a very high level of counterparty risk management. Fortunately, there is Introspector. We can use Introspector reports for this. We can use brokers. We should work with A1 charters, A1 brokers, and it's not difficult to find out the real situation about your counterparty, what is going on. Of course, the period of checking his performance, of your counterparty performance, should be limited, let's say, maximum 2 months, because within 2 months, I know a lot of cases when company became insolvent just within 1-2 months. So it's very important to check the performance within some short period of time. So to underline my speech, as for time charter operator, it's extremely difficult to prepare such tool. If for head owners it's difficult, for time charter operator it's much more difficult. So so we should prevent this. We should prevent this, and in order to prevent this, we should implement the extremely high level of counterparty risk management in your company. Yeah, thank you.
Super good. Alexei, do we have questions? I think that there was a question for Gennady from the audience.
Arthur, we have some discussion roles in the chat, so I will ask Richard this time.
Okay.
It was mentioned by Maxim Haulin, and it is continued to discussing in the chat whether the carrier can exercise the lien against the charterers if they are not the owners of the cargo. Is it possible? Once again, Richard.
From the top of my head, my first answer is no, because the charter it's a description. It's just somebody who has hired the ship. The lien has in some way to go in rem. It has to be attached to the property, and the value of the property in question, generally we're talking of the cargo. Now, does the charterer own the cargo? Now that's another question. Does it really matter? Because you are arresting the thing, you're arresting under the lien, you're arresting the property. It's for whoever is on the receiving end of that, whoever wants that cargo to come forward. It's voyage charter a little bit easier. That's a straightforward cargo owner, operator of the ship, or the owner of the ship, or the operator of the ship. That's straightforward. Time charter gets a little more complicated. Time charters usually have a clause which gives a lien on the cargo at all subfreights, because time charters they come in rows. Time charter of $5,000 a day today, maybe $6,000 tomorrow. Somebody's going to take that profit and move on. So there could be a number of time charterers. So you have under a time charter, usually the clause would give you a lien for subfreights and general average. That way you could get the charterer could have a lien on all monies paid in advance and not earned, maybe. But if the vessel is subchartered, that's interesting. The lien on the subfreight can only be exercised before the subfreight has been paid to the charterer. Okay, we're getting into, I need to see all the exchanges consider the actual circumstances of that particular case. Totally agree with the comments of voice charterer, manager, time charterer. You have to give notice. If there is a problem, you must spread the notice all around. I have a right to my freight. I have a right to Lien. The more you spread that notice, the better. Some people will come back and say, no, you don't have a right against me. Fair enough. You begin to narrow down against who that right can be exercised. But again, subfreight, hire, freight and hire, different things. Freight, yes, protected under maritime law in most jurisdictions. Hire, not so much. You have to spell it out, if you like, in the time charter, whatever, for that. Jurisdiction, always a problem. Common law jurisdictions, well, in the Mediterranean, you have Gibraltar and Malta, who operate mainly on common law principles, very flexible. Civil law jurisdictions, perhaps not so flexible. I mean, I'm interested to hear the comments Spain and Italy. Personally, I've always found dealing with the Italian legal system an absolute nightmare, with due respect to all my Italian friends and Italian lawyers. It takes forever and a day to do anything. The local jurisdiction is always going to be important. Yeah, that's your first hurdle. Some jurisdictions more friendly to arrest than others, yes, but they can change. It depends on how the judge got out of bed in the morning, quite often. The common law system, the English system with the admiralty courts, you will have judges who are experienced in shipping and trade matters. I have had problems with, in France, for example, with the Tribune de Commerce, which is basically a local court where the president of the tribunal was a butcher who knew absolutely nothing about shipping and such like. You try to exercise an arrest or lift an arrest in the Tribune de Commerce, very difficult. You may win, you may lose. You cannot predict. So it's very difficult to answer this question, Alexei.
Let's go. Let's ask.
Sorry.
Let's ask our lawyers. I mean,
sure.
Usually ladies first, but they finish the story. Yes, Celine disappeared. I said.
I'm here.
Okay.
I can see her. Yeah.
Yes, Celine, please tell on the Turkish side. What do you usually advise when clients come to you with questions on exercising a lien? What about Turkish judges?
Okay. First of all, a brief explanation. Lien on the cargo, is it possible under Turkish law? Yes, it is possible for certain types of claims. The carrier has a right to exercise lien right over the cargo for the unpaid freight, demurrage, and for all other claims arising from the charter party. Seller's lien right over the cargo. Yes, it is possible. General average, unpaid general average contribution of the cargo side. Then the carrier, the ship owner, has a right to apply the lien right. This is under maritime law, and these are the numerous clauses list. I mean, we are not allowed to create more rights, giving lien rights over the cargo by contractual clauses, by the agreement of the parties. It's not possible. In terms of the civil law, it's a very, very old practice. It's coming from the Roman law, and it is actually based the general principle of possessio. possessory rights. So in order to apply this lien right, the applicant should hold the custody right of the thing, the cargo. There are some exceptions to this rule, but I'm not going to be involved into the exceptions. Let's stick to the general rule. Yes, it is possible to proceed with the lien right under Turkish law, but the problem is again the same. There is a tripartite agreement, let's say, carrier, charterers, and the receivers. And in terms of a SIF contract, the seller, the charterers should pay the demurrage, let's say, or the freight. So what about the position of the receiver? The receiver, after the application of the lien right of the carrier on the cargo, can the receiver go to the court and state that his property rights are violated? Yes, it can be, but can we also counter argument this? Yes. For example, we are using this counter argument. We are saying that this is an in rem right. This can be applied to all parties in order to protect the right of the carrier. And in addition to that, we can also bring forward the clause 1 of the Kongen Bill of Lading, conditions of carriage. For example, the clause 1 is stating that all terms and conditions, liberties and exceptions of the charter party dated as overleaf, including the law and arbitration clause, dispute resolution clause, are herewith incorporated. So once the charter party, there is a reference to the specific charter party on the first side of the Bill of Lading, we can argue to the receivers that, look, this is a Bill of Lading, which is a tripartite agreement. So you are also bound by the rules of the charter party. So we are using this argument as well. So this is my answer. But in terms of Turkish law, yes, it is applicable, the lien right. It is set by the Turkish Commercial Code and by Civil Code. So that's it. That's my answer.
Can I just ask,
Yeah.
the Bill of Lading and the incorporation of the Charter Party, how would a Turkish judge look at that if those contracts specify domicile in the UK English jurisdiction? How would a Turkish judge deal with that?
Okay, exercise of a lien right is a precautionary.
Yes, agreed. Yeah.
Precautionary rights are subject to the Lex 40, the country of the law of the country of the judge. It should apply to this in rem rights. They are not open to a foreign law. But when you start the principal action relates to the merits of the case, to the debt, to the claim. Then the judge, there are two phases. First stage and second stage. Second stage is the main action. The judge is looking into the contract and searching for the applicable law. I mean, the judge is not doing this. Yeah. Parties are always guiding the judge. So that's the issue.
And in such circumstances, if the Turkish judge sees English jurisdiction, English domicile, he would go with that? Is that your experience?
No. He just saying that. Listen, I am not the competent authority here.
Okay. Yeah.
I keep the lien right, and you come with a foreign judgment or foreign arbitration award, and then until that time, I keep this precautionary right. I mean, the the
Yeah.
arrest or the lien, you see.
Yeah, in other words, your judge would say to the parties, you have agreed a forum, not my forum. Settle your argument there and come back to me.
Yes, yes.
Okay. Then we are in agreement.
Celine, thank you very much.
Arthur,
also-
I have a small question to Celine.
Okay,
Can
sure. Come on.
Can I, from the practice? Celine, what about the physical possession of the goods? One situation is when the cargo remains on board of the vessel, and the vessel is staying in the port, in Forest, etc., etc. And the second situation, when the cargo was discharged by the ship owner on the terminal, and the ship owner continued to pay for the fees for the storage, and thinking that he's continue to control the cargo. Does it change something in the
Yes.
practically in the court whether the cargo remains on board or already discharged? Thank you.
There are two different process for this. If the cargo is on board, the enforcement officer goes on board and makes a list and applies the lien right, give this right to the ship owner. I mean, not give, but he's writing this right on his minute. You see, and then what will happen next? The vessel is not a storage area. Of course, we have to go again to the court in order to determine a storage area. Another process. It's a simple one. So you have to find the ship owner. The carrier should find a suitable warehouse, and he has to pay the cost as well. Then these costs are recoverable from the sale of the goods. That's the first one. If the cargo is on board, but if the cargo is discharged, this is the exception actually, because the cargo should be under the custody of the ship owner. But the exception is that if the cargo is discharged to a warehouse and the discharge has been effected from a month is elapsed from the discharge and the staying of the lodging the goods into the warehouse, then the court, this time the court, not the enforcement officer, can decide whether the lien right is exercisable or not. When the cargo is on board, the enforcement officer is going to the is boarding the vessel. But when the cargo is discharged to a warehouse, remember there is a time bar of 1 month. Then the court is deciding whether the carrier has right to apply the lien right on this cargo stored in a warehouse or not. So there are two different process.
Thank you, Celine. Very clear.
I would just add to that when the cargo leaves the ship to the warehouse, the words to be used as an English arbitrator, identity always preserved. That has to be very, very important.
Yeah. Correct. Yeah, I agree.
Okay, Celine, thank you very much. And we have also Ukrainian lawyer Karina Gorovaya. Karina, please tell us your story from the Ukrainian perspective. I remember that in the practice of interlegal recently there was a case.
Yes, Artur, thank you. As for Ukraine legislation, of course, we also contains such concept as lien of cargo in maritime relationships. In particular, the Maritime Court of Ukraine has one of article according to which the carrier has the right of lien on cargo in the port of discharge as a security measures to secure his right to receive the payment of freight or damage by the consignee. So it should be only the port of discharge and securing only the obligation of the consignee. However, sometimes, of course, we have requests from our clients who wants to secure this tool in the port of loading, and their requirements against maybe shipper or some third-party charterer who is not the shipper, who is not the consignee of the goods. In this event, sometimes we may apply the general legislation of Ukraine, I mean the Civil Code of Ukraine, which contains two general articles as well concerning the lien of cargo or maybe retention of the cargo. According to them, the carrier in general, not only the sea carrier, has the right of lien on cargo if the cargo was forwarded to him for transportation, in order to secure his right to receive the freight or other payments concerning the transportation of the cargo. And the other one rule, more general, according to which the creditor in general has the right of retention of some property of his debtor. However, the same as in other countries, the several rules should be. The creditor de facto should possess the property, and this property should belong to his debtor. Then such possession of the property should be lawful. So the creditor hold this property lawfully. And the next one, the creditor has legal requirements to the debtor, who is the owner of the property. So these three rules. As example, as you said, really, we had recently a case according to which our client, it was a head owner, he asked if they may use the tool of lien of cargo in Ukraine. The story was the following. It was a chain of agreements. It was a time charter, then a voyage charter. The vessel was chartered in order to carry the goods from Ukraine. The vessel called to Ukraine before the war. The goods were loaded on the board of the vessel. The bill of ladings were issued, but the war started. The ports were blocked and were closed, and the vessel was blocked in Ukraine. The time charterer announced that the charter is cancelled, and he has no obligation to pay the hire. And the shipper of the goods, he was the owner of the goods as well. He considered the possibility to unload the cargo to the terminal. And our client, head owner, in order to secure his rights to receive the hire, considered the possibility the line on cargo on board of the vessel. We considered the situation, and we cannot use the article of maritime code because it was the port of loading, not the port of discharge, and we applied to the general rules, and our verdict was no. Unfortunately, they have no such a right because the head owner had not the legal requirements to the shipper. He had no strict relationships with the shipper of the goods. Yes. However, we had another idea, maybe some interesting. Unfortunately, we have not the possibility to check this, but the idea was the following. The head owner has the cargo on the board of the vessel, and de facto they are responsible for this cargo, and the bill of lading was issued. If we may consider the vessel as a warehouse, and if we may consider the bill of lading as a warehouse receipt, and because according to the Ukrainian law, the warehouse receipt, it's just a paper which contains some data, namely the name of the goods, the value of the goods, and the name of the person who transferred these goods. If the vessel is a warehouse, and if the head owner provides the services of storage, maybe we may ask to pay for such storage services, and our head owner will have legal requirements against the shipper and owner of the goods to pay these services, and we may use the instrument of retention of the cargo. But the grain agreement was signed. The parties, all involved parties, they signed a settlement agreement, and the vessel left the territory of Ukraine. So we had not the possibility to check this non-standard idea. As for the using of this instrument, this tool of Lien on cargo, to use it very simple. We just should note the debtor that we realize the right of lien on cargo, and just inform them in writing. But if the creditor want to dispose this property, this should be realized through the court only.
Can I ask a question?
Yes,
If I understood you correctly, you are saying in English, in Ukrainian law, this case established that there was no relationship between the carrier and the shipper. Is that what you said?
Could you please repeat?
Sorry, I noted down, I think you said that the court established no relationship between the carrier and the shipper.
Not between the carrier, between the head owner and the shipper, because the head owner was indicated as a carrier in the bill of lading. There were not, as we saw, that the strict relationship between the shipper under the bill of lading and the head owner of the vessel.
Okay, so
because there was a chain. There was a chance the ship was time chartered. Then
yeah, okay, so it wasn't an owner's bill of lading; it was a charterer's bill of lading. Okay.
Yeah.
Yeah. Okay.
Yeah.
Then I follow what you're saying. I perhaps clarify for my own position. Speaking of the head owner, I assume the head owner is the carrier, but you're talking of a situation where the bill of lading is not issued by the head owner, but by a disponent owner, a charterer's bill of lading.
Yes.
Yeah. Okay. Then I'm with you.
I have a question to Celine and Karina. What about judges? I mean, judges in Turkey and in Ukraine. Are they experienced in dealing with maritime lien? Or this is a case like Richard told us about, let's say, Bucha.
The Tribune de Commerce in France. Yes. Yes.
Celine, please.
Yeah, in Turkey, for the lien right arising, I mean, under maritime law, they're not very reluctant to see these cases, but this is a very old, very notable institution under Turkish law in terms of civil law, used by the repairer, by the by the construction workers. I mean, the person who holds the possessory right of a thing, of a good. If this person is not paid, he can use this lien right on the thing. I mean, there's a general practice, for example, for the rental contracts. So the civil law judges are familiar with the practice of the lien right, but the maritime judges, there's only one court dealing with in Istanbul, actually, dealing with this matter. They're not familiar with these types of claims because most of the cases are ended up with a settlement protocol. So that's the issue.
Thank you, Celine. Thank you. Karina?
As for Ukraine, first of all, we have no special courts which consider the maritime claims only. And as for the lien on cargo, I'm afraid that we even will not be able to find even one dispute in the court register which concerning the lien of cargo, very rare practice.
Yeah, so that's clear. So we are coming to an end. Alexei, do we have any more questions?
Yes, we have one more question at the end of this webinar, but I want to mention that we received answers for all questions in general. Of course, we have some very specific questions in the chat and received beforehand during the registration, which we cannot advise on or give answers without studying the contracts and the wording. So my advice to all the participants, if you not receive the answer today, please send us your questions to the interlegal email with attaching the wording of the contracts, and we will try to provide you with more specific answers. And the last question, I think it's to the Richard. Let's back to the sales contracts. The question is whether the non-payment of freight by the charterer, which is the seller, is a breach of the contract with buyer. Why do they need to have additional wording in the trading contract that seller is responsible for any delays at the delivery of cargo for non-payment? Unquote. This was the recommendation from Igor from trader side. So let's once again speak about the obligation of the charterer / seller in the sales contract and in the charter party. Thank you beforehand.
Okay, I liked Igor's clause of the seller not being responsible for delays of taking delivery, assuming the ship has arrived. I can't recall actually having seen one in any of the commodity arbitrations that I've been involved in. Not from memory. We come back to the basics of international trade. A fob seller puts the cargo on board. If it's fob stowed and trimmed, that is his responsibility, his liability. If it works, then the carrier, the actual carrier, can issue a bit of lading. If it's marked freight paid or prepaid, then the seller, the fob seller, passes that to his buyer. His buyer usually becomes a SIF seller, and those documents are being traded on. This is what is meant by, although we're talking of physical goods, we're actually trading documents, paper documents. I give you a set of shipping documents, which allows you to transfer property and title to the next guy in the chain, and so it goes on. The most important document to my mind, the bill of lading. Why? Because at the end of the chain, the receiver can demand delivery of the cargo from the ship owner, from the carrier, whether that's a disponent owner or head owner, actual owner, call it what you will. The bill of lading is the key to the warehouse door. He can go to the ship and say, give me my cargo. If the owner has not received freight, the owner has possession of the goods, and he's going to tell that bill of lading holder, not until I get my freight. The receiver may not say, well, look, I've already paid for my cargo. I bought SIF, so I've paid freight into my purchase contract. Somewhere along the line, there has been a hiccup, a barrier. Somebody is holding freight. It has not got to the carrier. The classic example, we've talked about this before, Arthur, Alexei, a Panamax vessel loaded in Ukraine, sailed away, freight paid bills of lading were issued, but the buyer of the cargo under the sale contract was in theory the charter of the vessel. He was actually under another company, all in the same house. He was actually the owner of the ship. The argument there was that the owner had not received freight from the charterer. As we found out later, the freight broker and the trader actually sat almost on the same desk. They had desks adjoining in the same office. But the argument was that the owner had not received freight from the charterer, and he tried to exercise a lien. It didn't work. It went on for ages. But this is the situation. I think it was Maxim makes the point of know who you are doing business with. Whether you're buying or selling cargo, trading ships, doing anything, knowing who you do business with is the most secure way of doing business. You cannot trade without taking a risk. Risk equals reward. If you don't know who you're trading with, the risk is enormous. Okay. The owner, we come back again and again when we talk of liens to the word possession. The right is against the property, to lien the property. We have this peculiarity in rem in personam. We play this game of treating the ship or treating the cargo or the ship, if you're arresting the ship, as a person. And in that way, the common law system is perhaps more flexible. I'm beginning to lose track of what I'm trying to say now. Liens do work. They mainly work because of the pressure being applied to the contractual chains. If you are an established seller of cargo, you want that cargo to arrive. The risk in that disappears when you present the shipping documents, because you're passing that risk on to somebody else in the chain. But your reputation is still as the originator of the cargo at one end of the chain. If there's a problem somewhere in the chain, if you're a big trader like Cargill, Louis Dreyfus, you want to sort, or the company I worked for, Andre, you need to sort that problem out to protect your reputation. But there are any number of problems that can arrive in that chain. We come back to the basics. The owner has a right to lien the cargo for freight and demurrage. That's a possessory lien. If he puts it into storage, yes, it goes under the protection of the court. The court approves, you can discharge, put it in a warehouse. Here, I would think that the owners, disponents, whatever, rely heavily on the help given by P&I clubs to look after those goods in the store. One case that comes to mind was a very entertaining case of coffee coming out of Kenya. Very clear. As the trading company involved, we obtained valid and proper shipping documents. They're signed by the agent on behalf of the carrier. What we didn't know was that that agent issued a second duplicate set of shipping documents. There were two bills of lading signed by the same agent for the same cargo. You can guess what happened, which bill of lading got to the destination first. The one that was not in our possession. So the ship owner is then faced with two original bills of lading, absolutely identical. You could not tell the difference. Who does he deliver against? The answer, with the P&I Club's help, the goods went into storage, in Hamburg. They went into the containers, went into storage. The case went on for years, because how do you discover? We had to prove the chain of payments to the original, the originator of the coffee, and eventually we established that this agent had issued two bills of lading. So the possibilities here are endless. You cannot give a proper answer without seeing all of the documents, all of the contracts. And even then, as the coffee story indicates, there are still tricks that can come up and surprise you. I'm sorry if that's a lot of explanation, but does that help, Alexei?
Yes, I think it does help, and you made very good conclusions. I mean, even I don't need to do it, because I'm really happy that the gentlemen and ladies that we invited today just proved once again that the best way is to do due diligence, to know whom you deal with.
Absolutely.
And I'm really happy that the gentleman today from shipping proved once again that they're wise enough. Unfortunately, or fortunately for us lawyers, not everyone in the market is wise as our speakers. But let's round up. Thank you very much that you were with us today. I would like to thank every speaker today. Richard, your input is great. Thank you very much again.
You're welcome.
Bravo. Thank you very much, Maxim. Thank you very much, Gennady. Thank you very much, Armando. Karina, Celine, thank you very much. And our headliners with the case study, Igor and Mykola, also thank you very much. I think we arranged a good discussion, Alexei. Yes, this was our idea to make it very live. A little bit, we are a little bit late, just 20 hours, but we had a number of people involved, engaged. This was very interactive. So the records will be distributed among all delegates, and it's very good that we are doing this interesting things. See you later. Thank you very much. Ciao. Bye bye. Have a nice day. See you later.
Yes, thanks, Artur, for organizing and inviting us.
Thanks to everybody.
Bye-bye.
Yeah, thank you.
Bye.
Bye-bye.
Thank you. Bye-bye.
Bye-bye.
Ciao.
Leave.